5 seconds to go. Start. Therefore, the short question which is posed for the consideration of this court is whether, in the facts and circumstances of the case, the punishment of dismissal can be said to be an unfair labor practice on the ground that the same was disproportionate to the misconduct proved, and therefore the industrial court was justified in interfering with the order of dismissal and ordering reinstatement with continuity of service. Having gone through the findings recorded by the inquiry officer in the departmental inquiry and the judgment and order passed by the labor court as well as the industrial court, and even the judgment and order of acquittal passed by the criminal court, it emerges that when the respondent was driving the vehicle, it met with an accident with the jeep coming from the opposite side, and in the said accident 4 persons died. From the material on record, it emerges that the impact of the accident with the jeep coming from the opposite side was such that the jeep was pushed back 25 feet. From the aforesaid facts, it can be said that the respondent workman was driving the vehicle in such a great speed and rashly, due to which the accident had occurred, in which 4 persons died. Even while acquitting the accused respondent driver, who was facing the trial under section 279 and 304A of IPC, criminal court observed that the prosecution failed to prove that the incident occurred due to rash and negligent driving of the accused respondent herein only and none else. Therefore, at the best, even if it is assumed that even driver of the jeep was also negligent, it can be said to be a case of contributory negligence. That does not mean that the respondent workman was not at all negligent. Hence, it does not absolve him of the misconduct. Much stress has been given by the industrial court on the acquittal of the respondent by the criminal court. However, as such, the labor court had in extenso considered the order of acquittal passed by the criminal court and did not agree with the submissions made on behalf of the respondent workman that, as he was acquitted by the criminal court, he cannot be held guilty in the disciplinary proceedings. Even from the judgment and order passed by the criminal court, it appears that the criminal court acquitted the respondent based on the hostility of the witnesses, the evidence led by the interested witnesses, lacuna in examination of the investigating officer, punch for the sport panchnama of the incident, etc. Therefore, criminal court held that the prosecution has failed to prove the case against the respondent beyond reasonable doubt. On the contrary, in the departmental proceedings, the misconduct of driving the vehicle rashly and negligently, which caused accident and due to which four persons died, has been established and proved. Stop.